everyone. Today we're talking about the reasons for the court hierarchy in the civil sense. All right, so if we look at the study design, you need to know two reasons for the court hierarchy in civil cases. So make sure you don't get these mixed up in the exam. If it's asking you about civil, make sure you choose one of these two, and make sure you're specific that you're talking about civil. Okay, there's two reasons. It's for administrative convenience, and it's also for appeals. So quick recap of the court hierarchy. At the bottom, we have the magistrates. Then we have the county, Supreme Court of Victoria, Supreme Court of Appeals, and then finally the High Court of Australia. So remember, we're getting more serious as we go up. Okay, so the first reason we have today is it's for administrative convenience. Okay, so it's related to this idea, and I've dropped my pen, this idea of general organization. Courts only have a certain amount of resources and finances. So it's important that in order to reduce delays and reduce financial burden on a plaintiff or a defendant, that we, by allocating cases to based on their seriousness and complexity, we're going to reduce both delays and costs. Okay, so it makes the court system more efficient by organizing it in a way that's going to allow people to pursue their case quickly. The court jurisdiction, or the jurisdiction of each court, is clearly established. So magistrates court, for example, here's minor cases. And people shouldn't have to waste time and money in initiating an action in an inappropriate court or the wrong court. Okay, so by ensuring that people go to the correct court, we're reducing delays and we're also reducing cost. You're probably wondering how this differs from specialization. Specialization is about the competency of the court. Okay, so it's about magistrates being expertise in a particular area, whereas administrative convenience is about the organization. So making sure the right people go to the right court to make it efficient and faster. Okay. So a couple of things with administrative convenience. By having this court hierarchy, it means cases can be distributed according to their seriousness and complexity. It means minor disputes are heard relatively quickly and quite less expensive, and it means that more serious disputes and more complex disputes can be heard in either the county or Supreme Court. Lastly, if you've got a class action, which we know are more complex cases, which usually take longer and require a judge to have greater expertise, they will go to the Supreme Court. So we're not seeing class actions at the bottom of the court hierarchy. We're making sure that we allocate it in the correct spot. Again, improving efficiency of the court system. So it's all about efficiency. The second reason for the court hierarchy is, again, appeals. Okay, so a reminder that the court hierarchy, or having courts from less serious to most serious, allows appeals to work effectively, as someone who's dissatisfied with an outcome in their court case at a lower court can actually appeal to a higher court and get their case reviewed. There's a couple of different reasons for appeals in a civil case. Some of the reasons that you can actually appeal your case is on a point of law, or known as a question of law. This is where the law has been incorrectly applied in your case. So for example, if a court hears inadmissible evidence or applies the wrong legal test in a case, you may be able to appeal your outcome and take it to a higher court. Okay, so if the court has done something wrong in regards to interpreting the law and then applying it in your court case, then you have grounds for appeal at a higher court. It might be a question of facts. So whether the facts of the case, so the who, what, when, where, how it happened, whether they or not they've been applied in the appropriate way and been examined in the appropriate way that actually leads to a decision. If it hasn't been applied in that way, then you may have grounds to appeal. And lastly, it might be on the remedy awarded. Okay, so what did you get at the end of your court case, and the way in which the court might have enforced a particular right or order by made. Okay, so if you're unhappy with the compensation or the injunctions, perhaps you would take that to a higher court. Okay, so in summary, just so you can see where you apply, the original jurisdiction is what courts can hear at first point. So if you're initiating a claim for the first time, then the magistrates can hear up to $100,000. County court can hear unlimited claims. Supreme Court can hear unlimited claims and class actions, we know. And then at Supreme Court of Appeal, they have no original jurisdiction because you're not going to go there for the very first time or the very first case. From there, we can look at the appellate jurisdiction. So where do you go if you want to appeal? So obviously at the magistrates court, you're the lowest court, so no one's going there to appeal. If you want to appeal, you cannot go to the county court unless they're specific, or unless they've been given specific powers under Acts of Parliament, but we don't really need to talk about it. So it's unlikely that you'll ever appeal straight to the county court. So if you're going from magistrates court or from BCAT, you will go straight up to the Supreme Court. And at the Supreme Court will look at a question of law. So whether the law has been applied incorrectly at the magistrates court, and very, very occasionally at BCAT, although it doesn't happen very often. At the Supreme Court of Appeal, they may look at a question of law or the question of facts, or alternatively, they may also look at the amount of damages awarded from a county or Supreme Court. So normally it goes up, as you can see here. All right, that's it for today. Happy studies. Bye.